In Second Amendment news, the state of Illinois has urged the U.S. Supreme Court to not block its ban on assault-style weapons under state law. So we've covered this before in various states. We covered this recently in California with the California State Appeal Court ruling somewhat surprisingly that AR-15s are not a firearm that's in common ownership, despite the fact it's the most common rifle in the United States, but somehow not in common ownership for lawful purposes. I'm not quite sure how the California court came to that conclusion. Other states have come to similar conclusions, for example, Illinois, but other places have come to different conclusions. And so there is now a conflict between these various decisions. So one would imagine the U.S. Supreme Court will get involved eventually. Whether they'll get involved now is a whole nother set of issues, but, you know, the state of Illinois would prefer it not be now. So the gun shop owner, of course, has asked the Supreme Court to overturn lower rulings upholding the ban, and Illinois would prefer the Supreme Court not get involved very much. Let's learn more. The attorneys for the state of Illinois have urged the Supreme Court not to block local and state laws banning the sale of what the state considers to be an assault-style weapon under state law. The gun shop owner, named Robert Beavis, has challenged the town ordinance and state law that ended the sale of weapons, arguing that they violate the Second Amendment, because it almost certainly does. Because the Supreme Court talked about ordinary and common firearms in, for example, Heller, which this is an ordinary and common firearm. It's a rifle. It's a semi-automatic rifle. It might have some furniture, as they say, you know, some appearances, but it fundamentally is just a rifle. And so it's an ordinary and common one. And as we noted, the AR-15 in particular is the most common rifle. So, you know, it probably violates the Second Amendment, which allows people to have ordinary and common weapons for lawful purposes. The gun shop owner has so far failed to persuade the federal judges in Chicago, unsurprisingly, and asked the Supreme Court for an emergency injunction. Probably won't get an emergency injunction, but they might take it up on the merits. Justice Barrett, who reviews these requests as the circuit justice, requested more information. So just as a matter of how this is done as a matter of protocol, every justice on the Supreme Court is given one or more circuits as the circuit justice for the purpose of like emergency appeals. They can act on their own behalf, or they can refer to the court as a whole, which they almost inevitably do, even if they act independently. So sometimes they'll just refer to the court completely. Very rarely will they act on their own behalf, and then usually they refer to the court. It's nigh on rare as rare for them to just act completely independently. But they can technically, as circuit justices. It's an old holdover, but they still have the power. They just never use it for obviously more modern reasons. So Amy Coney Barrett was assigned to this particular circuit because I don't know reasons. And if they decide amongst themselves who gets what circuit, and she's the circuit justice. So she's requested more information about this as she considers the request. The state and town filed their responses mirroring arguments they've used successfully in the Seventh Circuit Court of Appeals. So the Seventh Circuit thinks, you know, these bans are fine, and I'm sure the Ninth Circuit would agree. But the Fifth Circuit probably would disagree, as other circuits would. So eventually, the Supreme Court's probably going to get involved. Both have argued the injunction is not justified because the chances of winning are not certain. Yeah, I mean, injunctions are by nature an extraordinary remedy. So granting the injunction now is one legal issue versus the ultimate merits issue. So will they grant the injunction? If I were a betting man, probably not. Probably won't grant the injunction. I mean, it is an extraordinary remedy, and they're rare, and they're never required as a matter of law. But the merits someday is going to come to the Supreme Court. The state wrote in their briefing that a single business person claims he may suffer financial loss because he cannot sell a limited category of an extremely dangerous assault rifle of limited practical use for self-defense. I'm sure some people in the gun community would challenge that conclusion, but that's what Illinois seems to think. At the same time, the residents of Illinois will be placed at additional risk of mass murder. Well, we know how Illinois views the question. Those consequences far outweigh speculative and purely monetary business concern. Okay. Weeks after a gunman opened fire at a parade last year, the city council adopted an ordinance banning the rifles. A similar statewide ban took effect in January. Beavis, who is the owner of Law Weapons and Supply, filed a challenge to the ban and claims he's lost hundreds of thousands of dollars in sale. Federal judge denied his request, and the Seventh Circuit also denied. A federal judge in Illinois was persuaded to issue an injunction against the state law last month, but the Seventh Circuit unsurprisingly overturned him because it's the Seventh Circuit who, of course, is going to do this. Beavis, who along with National Association of Gun Rights argues the Second Amendment, says that, these are lawful firearms, which, given the relevant law, I would tend to agree. This is an exceedingly simple case, the lawyers wrote. The Second Amendment protects arms that are commonly possessed by law-abiding citizens for lawful purposes. That's basically what the Supreme Court wrote in Heller. Yeah, almost exactly those words. Ordinary and common, I believe, were the words exactly in the case, but, yeah, so this issue is definitely percolating through the courts, and Illinois would prefer it not to, but someday it will. Thus, that brings us to the end of the discussion for the moment about the Second Amendment as it exists or lack thereof in the great state of Illinois. Illinois would very much prefer that you not own dangerous, scary-looking weapons like the AR-15, a semi-automatic rifle, like pretty much all rifles are semi-automatic, but it looks scary. And it has, scary features, and it's black and stuff, and we don't like it. But the Supreme Court has said the Second Amendment extends to ordinary and common firearms. And then recently, of course, in Bruin, the U.S. Supreme Court said that the correct test when it comes to the Second Amendment is a historical analysis, because that's how we do First Amendment analysis, for example. If you want to know what the freedom of speech does or does not cover, when you can, for example, ban words or ban written words or spoken words, if you want to know, hey, can we ban these words? Can we do it in this situation, that situation? If you want to know, can you do it? The right way to go about such analysis is historical. What does the First Amendment cover and what didn't it cover? What is its boundaries? And that's an historical analysis. So what if we did the exact same thing when it comes to the Second Amendment? So yes, just because it's spoken doesn't mean that it's protected by the freedom of speech. We know this. And by the same token, just because it's an arm doesn't mean it's protected by the right to keep and bear arms, because of course that would logically flow. But you have to do the historical analysis. And rifles were owned and in common use and have been since the founding. And the fact it's a slightly more modern version, well, the internet's a more modern version of the First Amendment. The First Amendment protects the internet, so, and it's ordinary and common. So the historical analysis would seem to suggest that these arms should be allowed. But they would like to delay that day as long as they can. Unclear if the Supreme Court will take this up in the near term, but I imagine they will within the next couple of years. And that, for the moment, brings us to the end of discussion of this story.